a big concern with Chud, of course, is this question of provocation, right? Did he provoke the fight? And normally the defendant in a self-defense case can only bring into evidence things he knew about his attacker. I had personal knowledge this guy had a long criminal record, right? If you didn't know it, you can't bring it into evidence. But there is an exception. The exception is if the prosecutor attacks your claim of self-defense on that element of innocence, that you were the aggressor or you were the provoker. That opens the door for you to introduce evidence about the other guy that you did not know at the time. Because what the prosecution has done by attacking that element
that's crazy. So one more so because this kind of goes against what we discussed before. If you don't know certain things, you can't bring it later.
You can't get it in. Right. So this is an exception to that general rule. We mentioned the 5 elements of self-defense, right? One of them is innocence. You started the fight, basically, either because you were the initial aggressor or you provoked her. Well, that raises a question for the jury. Well, who started the fight? So what becomes relevant is, well, who between these two guys was more likely to have started the fight? That opens a door to admit evidence that the other guy has a history of violence, even if you didn't know about it, because that's relevant to whether or not it was more likely that he started the fight. Gotcha. So what I would do if I were Chud's defense attorneys, what I would say, listen, I just want you guys to know, if you're planning to attack my client on this issue of provocation, I'm going to bring in that other guy's entire criminal history because you'll have opened the door to doing that. And that can prevent the prosecution from bringing up the provocation issue in the first place because they don't want that other guy's criminal history coming into the record.
Wow. That's a bombshell. That's a bombshell. Because in this situation...
So you tell them, listen, you can accuse my client of provoking if you want, but if you do that, I'm going to get that other guy's entire criminal history. The fact that he tried to burn down the building his ex-wife is in, that's all coming in. And otherwise it wouldn't.
Yeah. Yeah, because I remember even
so a lot of times prosecutors will say, oh, shit, well, then we'll attack him on other things. We'll say he went to the gun too soon. We'll say he was generally being unreasonable, but we're not going to bring up the provocation issue, which would be a huge win for Chud. That's obviously a big point of vulnerability.
I would argue that's like the linchpin is the provocation, because I think a big reason why they went so hard at this guy and came after him is because, well, this guy walks around and provokes black people all day, right? This is what he does.
I think that's right.
This is his shtick. He provokes. He starts the fight. It was just a matter of time. He's trying to do this for clicks and for views, etc. And then even in this situation, right, where they're gonna, because the default assumption by everybody is he provoked this fight. So even with him disengaging, they still assume now he provoked the fight or whatever. But what you're saying is, if the prosecution intends to bring it in, which we know they're going to try to, of course, that's going to be probably the cornerstone of their argument, is that this guy is a provocateur for clicks. The defense attorney can counter and say, okay, you want to play that game? We will bring in your star witness and destroy his credibility.
Even if our client didn't know anything about him.
That's actually, wow. That's huge, man. Because, some prosecutors might say, damn, my star witness is kind of a piece of shit. Like the guy has a criminal history. Right. There's the face, because I saw social media posts where he literally was saying like, yeah, I'm going to get Chud. I'm going to get rid of him, blah, blah. So now because the key is, did Chud know this? Let's say you're his attorney. He tells you, no, I honestly, sorry, Andrew, I didn't know about this stuff that he threatened me. That might explain why he was saying, I'm going to get you, blah, blah, blah. But I didn't know that he had said this stuff about me on Facebook. But now the prosecutor says, well, we're going to introduce that he provokes people. Then you could counter, oh, well, you know what? I know that your client, or not your client, I know your star witness had made posts days before threatening that he was going to find him and kill him. And it doesn't matter that Chud didn't know because now I'm going to use this. And that might scare them from using provocation.
Right, exactly. So, and the problem is
he needs to hire you, Andrew. He needs to hire you.
Know this.
He needs to hire you. Wow.
Most lawyers don't know this. Most lawyers, I talk to criminal defense lawyers.
You just killed their case, Andrew.
30-year careers. And most of their self-defense cases are bad guy cases of self-defense. And so they've only had 3 or 4 good guy cases of self-defense in their career, like once every 8 years. You don't get good at it if you do it once every 8 years. So they don't just know that they don't know this stuff because they've never encountered it. But that's why people hire me.
No, I mean, dude, this is like, that's unbelievable. Like, and this is the importance of hiring a lawyer that I would argue right now, what you just said, you just destroyed the prosecution's main argument that they're going to use. Because I think a whole reason why they went after him, why they made the arrest, etc. Obviously, it's from a cover your own ass perspective. From their perspective. Right. Yep. But I would argue that what they're also going to say is that, this guy's a danger community, he provokes, blah, blah, blah. but but this guy that he got into a fight with is a piece of shit. So that might disarm the prosecution's provocation argument, which I would argue is literally the underlying factor as to what they're going to go after.
Now they have to make a decision, right? Do they want to give up that line of argument, or they want to go forward? And then the jury gets to hear all that stuff about their star witness on cross-examination. Isn't it true you said this? Isn't it true you did that? And it has an effect of deflating the histrionics of the defendant, of Chud the Builder, right? Sure, he says crazy shit, but their star witness says crazy shit too. Maybe it's a wash.